Good afternoon, everyone. My name is Merrick Green. Here with me today is Lewis Rhodes. We'll do quick introductions in a minute, but thank you for joining us today for this webinar, Politics in the Workplace, Employer and Employee Rights. As I was thinking about interesting topics for employers and issues that we've been getting from some of our employer clients over the last several months and years even, politics in the workplace has really been a hot issue. As we all recognize, politics has become more and more divisive within our community, with people holding stronger viewpoints, and especially in the workplace, it is a topic that companies need to be very, very weary of. So with that, we thought it would be a great topic and hopefully of interest to everyone who is attending here today. And then we'll also post this on our website so people can see this in the future. So let's move ahead without further ado. And number one, before I go ahead and introduce Lewis Rhodes, I just want to make sure, Lewis, you can see our second screen now, which is about General Counsel?
Yep.
Excellent. All right. So just quickly about General Counsel, our primary offices is McLean, Virginia. We represent businesses, nonprofits, individuals throughout the DC metropolitan area, and we also represent companies and foreign companies as their U.S. counsel across the United States. We have 4 primary practice areas. Corporate and M&A includes everything from, drafting business contracts, reviewing leases, helping with state and local regulatory issues, to helping with M&A transactions, buying and selling businesses. I think in the past 2 months, we've done about 6 M&A transactions. I lead our labor and employment law practice, and that is day-to-day counseling to employers about hiring and firing, non-compete, non-solicitation agreements, and everything included, a number of employee investigations and the like. I'll let Lewis talk about our government contracts practice in a second. And our 4th practice is dispute resolution litigation. That is state federal court litigation throughout the DC metropolitan area. We're licensed in DC, Maryland, and Virginia, and we're also doing significant mediation and arbitration. Quickly, my background: I founded General Counsel in 2004. I've been practicing employment law since 1997, and enjoy working with employers on these issues. Lewis, do you want to give a little bit of your background and also talk about our government contracts practice?
Sure. My name's Lewis Rhodes. As Merritt said, I lead our government contracting practice, primarily, everything from, contracts and company structures and organization, SBA, set-aside regulations, through bid protests and claims, kind of run the gambit across the board in government contracting. I've helped on some of our M&A deals involving government contractors. There's a lot of special issues in there relating to government contract specific matters. Currently got a couple bid protests out, one in front of the SBA and a couple in front of GAO that have been keeping me fully occupied lately. Prior to coming here to General Counsel about 7-8 months ago, I spent the previous 6 years as an in-house counsel for various government contractors. And in that role, I kind of got to touch on everything. I work primarily in small businesses, so got to be involved with a lot of proposal writing, a lot of pricing out proposals, and touched on a lot of the legal issues and compliance issues that touch contractors. And along those lines, this is an issue of, as we dive into it here, political speech is rife for problems on the inside workforce. The unfortunate reality is, and I think you only need to spend 5 minutes on social media, is no matter what you do, you're going to offend somebody. So trying to walk a line that doesn't offend anybody is challenging. And I think as we go through this, Merritt's going to point out a bunch of areas where really trying to stay content neutral is your best path.
Great. Thank you, Lewis. One thing that Lewis left out of his background is he is a graduate of the Naval Academy, has been in the Marine Corps, and is still within the reserves. for 27, 28 years. So,
26 and a half. I'm not that old yet.
not that you're counting.
No.
Quickly, disclaimer, you can look at this. This is general information purposes. All right, relevant laws that we're going to be talking about. We're going to talk about the First Amendment, or more precisely, we probably won't be talking about the First Amendment. We'll review the National Labor Relations Act, which is really going to have the most impact on how political speech can be regulated within the workplace. And then
Mary,
we'll
your slides are not advancing.
Oh, do you see it now?
Yep.
All right. We're talking about the National Labor Relations Act, and then we're going to talk about state and local laws. Thank you for that. All right, quick, First Amendment. And before we get into this, use the questions tab within the webinar features and the tools. If you have any questions, we'll either answer those as appropriate as we go along or answer them at the end of the presentation. But that is the best place to ask your questions as we go along. And please ask as many as you can, as many as you wish. So First Amendment, freedom of speech. Oftentimes we'll talk to an employer and the employer will say, you know, I'm worried about what we can say, or tell our employees not to say because they have First Amendment rights. Boulder Dash, there is no constitutional right to free speech in the workplace. Freedom of speech protections apply to government action. You know, so unless there are state laws providing protections to employees, and certain states do, California, Colorado, and Louisiana, all prohibit discrimination based on political beliefs. But DC, Maryland, Virginia do not have strict prohibitions on restricting political speech. So First Amendment is not a right that your employees have within the workplace. So employers can restrict political speech at work, and we'll go into some of the restrictions on how they can do that. So as a general matter, political discrimination is not unlawful discrimination. Now, there's a whole can of worms there that we'll go into, but that is sort of the general premise that we have as we're going through this. Now, a quick caveat. Today, we're really going to be talking about private workplaces. There are different rules for public employees, so government employees, because they do have federal constitutional provisions, including the First Amendment, that provides certain protections for those public employees. So if you're a public employee listening here today, I'm sorry, we're not going to get into all of the issues related to regulating public speech as a government employee, but there are different rules that you should be aware of. The other thing that I want to touch on quickly here, but we're not going to sort of go through in detail today, are special issues for nonprofit organizations. And again, nonprofit organizations will be private employers, and they'll have a lot of the same restrictions that we'll be talking about today. But they also have an issue where if they're a 501c or other sort of nonprofit with tax-exempt status, there could be strict prohibitions on the political activity or lobbying actions that they can take as a nonprofit entity. And they need to be very careful that actions of their employees are not inferred or ratified by the organization. So you don't necessarily want employees on your nonprofit emails or Twitter accounts or social media going out and doing a tremendous amount of lobbying or other political activity, because that could come back potentially and impact the nonprofit. So if there are any nonprofits here today, something to consider and make sure you look into further. So as we said, no particular First Amendment rights, and generally political speech, as we said, is not prohibited. That being said, you need to be careful and aware. You know, as we all know, and as Lewis alluded to, political discussions can often include issues involving race, sex, national origin, religion, you know, that can be interpreted as workplace harassment or discrimination in violation of Title VII, the Americans with Disabilities Act, the Age Discrimination Employment Act, or other anti-discrimination laws. So many of today's political issues are tied to societal issues. That is just something that you need to be very weary of. And it's another reason why employers should have good policies in place relevant to workplace politics and political activity. I've seen more than one case where an employee was complaining of discrimination or harassment of one form or another, and as evidence they used, my boss was wearing various, Republican or Democratic, T-shirts or hats, or the managers were talking about political issues, and I felt offended because, it impacted me in one way or another. So it is something that, although you cannot necessarily, there aren't restrictions federally on political or restricting political discourse and activity in the workplace, you need to be careful of its impact on employees. I don't know, Lewis, do you want to add anything on that topic? What you saw?
Yeah, actually, I can tell an actual real life war story on this one. So when I was in-house counsel for a government contractor, we had an employee that had a MAGA hat in her office, sitting up on a desk. And whether you agree with the perspective or not, there are a lot of people who feel that the president is racist, and anything that specifically ties to him is racist. So it became an issue of, I'm offended by this hat because I believe that it's racial speak. We were able to, resolve it. It was another senior executive at the company, and they just agreed to take the hat away. But it could have been ripe for a problem because, we did not have good, clear policies on political speech and endorsements in the office. And this can very easily go sideways. So step one would be make sure you have some clear guidance and policies that are very content neutral. If you talk to any First Amendment lawyer, whenever the government gets involved in First Amendment restrictions, it has to be content neutral. And while there may not be laws dictating certain things to companies, if you get accused in an EEO action, if your policy looks like, hey, you can't wear a Black Lives Matter shirt, but you're okay to wear a MAGA hat, you're going to have problems. So again, I'd stick to very, very content neutral policies, but make sure you have them and you have them in writing so you can point to them before you make decisions about what people can and can't wear or display in the office.
No, that's absolutely right on, and we'll get into some more of those policies as we go along, and that how important it is to have those policies in place and make sure that they are neutrally and uniformly applied, so you don't get allegations of discrimination based on, these policies were applied against me, but not against, Susan. Therefore, it's discrimination based on my certain protected class. But anyway, going on to our next slide. So we said you don't have First Amendment rights here for employees within a private employer. So what restrictions are there? And a lot of times, most employers don't think about the National Labor Relations Act. A lot of times, the National Labor Relations Act is thought about, it's dealing with unions and collective bargaining. And we're not a union. We don't have a union. I wouldn't even know what a union organizer looked like if one hit me over the head. That's a mistake. And in this regard, the National Labor Relations Act provides protections for non-supervisory employees to engage in collective activities for the purpose of collective bargaining or other mutual aid or protection. So what does that mean? It means generally that employees who are acting collectively, so it's not just perhaps Joe going out and advocating that he wants to have a better uniform. It's Joe going out and advocating on behalf of him and other employees that the uniform that they're wearing doesn't adequately protect them based on the weather or working conditions. So it is collected, concerted activities for mutual aid or protection. So as we go here and talk about political activities, we can have restrictions on political activities, but when those political activities bleed into and become intertwined with workplace issues, that's where we need to be careful, and that's where the National Labor Relations Act comes into play, and we need to be, as employers, be very careful. So, for an example, if a construction worker is advocating for police reform, that's not going to be protected by the National Labor Relations Act. It's not working conditions, it's not an issue particular to himself. But if he was advocating for the safety or higher wages, it would be. Same thing. If that same employee had a sign on his desk that said, "Vote for Smith," that can be prohibited as political speech that you don't want in the workplace. But if he or she had a sign that said, "Vote for Smith, she will raise the minimum wage," that might be protected by the National Labor Relations Act because it is talking about workplace terms and conditions. So you need to keep that in mind as we go forward. So here are some of the prohibitions that the National Labor Relations Act does not interfere with. So these are things that the employers can do. You can prohibit purely political communications. So as we were just talking about, purely political you can prohibit, but if it starts bringing in terms and conditions of employment, you need to be careful. You can prohibit employees from soliciting money or support for political candidates or causes during working time. You can prohibit distribution of materials about those subjects in working areas during working time. And you can prohibit workplace communications or conduct that disrupt operations or productivity or are accompanied by violent, unlawful, or other extreme behavior. So as you can see, you're allowed to have some restrictions, but the rights of workers, in particular workers that are working with unions, but workers in general and what they're doing, they have particular rights that are protected by the National Labor Relations Act. So as we go forward, that is something to consider. And then we go into state and local laws. Different states, you need to look to see where you are. Here in the DC metropolitan area, the District of Columbia prohibits discrimination by an employer because of an employee's political affiliation or belonging to or supporting a political party. So that is a grounds of unlawful discharge if someone is fired for those reasons. In Maryland, Howard and Prince George's, not Price George's, Prince George's counties, it's illegal for employees to discriminate on the basis of an employee's political opinion. Virginia does not have similar laws. So it's something to keep in mind. So those are the general parameters. We have First Amendment, we have National Labor Relations Act, and then we have some state and local laws. We'll get into a little bit more nuts and bolts now. So the issue is you have an employee, and let's even think about some of the real world examples. We have the woman who, I think it was probably 2 or 3 years ago, was riding her bike near Trump National Golf Course, and the motorcade rode by and she flipped the bird to the motorcade. She worked for a government contractor. Shortly thereafter, she was fired. Think about whether or not that is something that would be allowed to do. It was a political activity, expressing her opinion, political opinion, when she was off duty. Generally speaking, there must be a legitimate business reason for the restriction for the off-duty activity. Company's reputation, legal liability, disruption in the workplace. So in this circumstance,
can I ask a question? So I want to chime in and ask a question here on you because I think it's kind of relevant to that case because that's a pretty good example. Do you think from the company standpoint that it had anything to do with the fact that she on her social media feeds was tying her employment with the company to the same feed of the picture of her flipping off the president? So she was tying her off-duty social stuff with her employer through her social media. I looked at that as probably a big factor, and I didn't know what your thoughts are on that with employees when they're off duty, but they're affiliating themselves on social media with their employer.
And that's exactly what the company looked to when they fired her. They fired her for violation of their social media policies, and they subsequently brought she brought a wrongful termination action that in Fairfax County Circuit Court that I believe was eventually resolved, and she was provided some severance pay, but I don't believe that it was ever determined that the company did anything wrong in that regard. So they had policies related to using company social media, and that's what they relied on here. She was, as Lewis talked about, expressing her political opinion, taking political activity, and tying it to the company, using her company account, social media, or referencing her company. And as a government contractor, the company said, no, you can't do that. We cannot, take a political opinion, as a government contractor, and they terminated her employment. And I think that's a opinion that I think would be safe to do, and most companies might do in that circumstance, depending on the situation. The next things that you can do, political activities when off duty, is attendance policies. You have attendance policies. You have an employee that needs to be there. They miss work because they go to the political rally. In that circumstance, you can terminate an employee because they went to that political rally, and it's because they missed work. It's not because they went to a particular rally. It's because they missed work, and they had an attendance policy in place. You do need to be careful when you're restricted. I'm sorry, did someone say
Darren, I have a question on that. What if I request a day off from work and I say I'm taking the day off so I can go take part in a political rally, and my company decides to deny it?
Yeah. I think that's one I'd wonder why the company would deny it. I mean, obviously, if they have a legitimate business reason, we can't afford to have you not working this day because we don't have anyone else to take care of the shift and we need you. And the employee says, well, tough luck, I'm going to this political rally. I think in that circumstance, it's an attendance issue. I think where you also need to be careful, though, is where attending a certain rally is not just a political event, but then it again becomes tied in with workers' wages, terms and conditions of employment. So it becomes tied in with National Labor Relations Act issues. So if the employee says, no, I can't come because I'm attending a rally tomorrow supporting minimum wage rights for all workers, and the company fires the employee on that, then you have to be careful that it could violate the National Labor Relations Act, and you could have an unfair labor practice brought against the company. So you have to be careful in that regard.
Yes, I would concur. And I think the key is, if you're going to deny something like that, my advice would be to have a very, 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 very good reason. And I would advise, if I was an in-house attorney and that came on my desk, I would advise the company to move mountains to let the person go before they denied the vacation request. Unless it's, some vital employee and it's a secured environment and this is the only employee who can access the security clearance or something of that magnitude. That's a very dangerous slope to step on.
Exactly. All right, workplace policies. So again, and as an employment lawyer, and I'm sure Lewis can talk about as in-house, the most important thing to do as an employer is have good policies and procedures in place within an employee handbook that you've thought through, that managers and supervisors are aware of, that are distributed to employees, and that the employees know of them, so they know what is expected of them, and what are the guidelines for the company. So as an employment lawyer, I will always, anytime I talk to an employer about any issue, that is a soapbox that we are always going to be on, and that we're always talking about. You need to have these policies and procedures in place. So different things that you can do. Political campaigning. Can you restrict campaigning or distributing political materials while at work on work hours? You can sometimes. The National Labor Relations Act has exceptions protecting employees' rights related to protected concerted activity and speech about union-related activities. Same issues with use of an employer's equipment. Generally employees don't have the right to use company equipment for non-work purposes. Quickly as we're going through this, within any sort of employee handbook or other company policies, you also need to make sure that you remind employees that they have no expectation of privacy as it relates to any company equipment, email, computers, and the like. So the employers can not only monitor it, control it, but you can limit the employee's use of computers and email for political purposes. But the NLRB has held that employees typically have the right to access work systems to engage in protected activity under the National Labor Relations Act. So that's, again, when it bleeds from political purposes to terms and conditions protected by the National Labor Relations Act, you need to be careful in that regard. Going forward into dress codes. Dress codes are always interesting in what can and cannot be done. And there have been a number of cases recently that have gotten press and really brought some bad publicity to companies. But as general rule, companies can enforce reasonable dress codes in the workplace. Dress codes can prohibit employees from wearing badges, pins, buttons, and clothing with political messaging. Where again, you need to be careful is where the National Labor Relations Act comes into play, and you have, mixed messaging. So it's political and mutual protection. Vote Smith for a higher minimum wage. That may be allowed where just vote Smith won't be allowed. Where else you have issues, and this is where it's been publicized quite a bit, is Black Lives Matters. You've had an employee who, I'm not sure which state he was in, I think it was perhaps in Texas, wearing a Black Lives Matter face mask in a position where he was facing customers, and he was asked to take it off and refused to do so and was terminated. He brought a racial discrimination suit based in part that he was asked to take this off. And part of his argument was other employees were wearing, personalized face masks. That was what they were allowed to do. One or two might have been wearing Blue Lives Matters face mask, and why was he singled out? And it's just not only a message and how you need to uniformly apply these practices, but this company was dragged through the press, and it was it really hurt their reputation. So you need to be very careful in having these policies in place and how they are enforced. If you have a policy that no political messaging can be utilized, then that would be what the company can say. I'm sorry, no blue lives, no black lives, no political messaging at all. It is, we don't want to have political discourse in the workplace because it can be too divisive. That is the rule that should be done. Lewis, anything to add on to that?
No, I think this goes back to my point from earlier that it really has to take painstaking precautions to be content neutral. But there's other factors at play here outside of speech, and there's what's legally allowed, and then there is the fallout of social media and cancel culture or whatever else you want to call it. So unfortunately, you may have the correct legal answer, and that may not prevent issues. So these are areas rife with problems. If you're a company and you're like, hey, I'm not going to let you wear a Black Lives Matter shirt or mask, because I have a policy of no political speech. You may be 100% right, but you also then may be vilified on social media. So, you know, I know we're running out, we're drifting out of purely legal areas, but I just want to make sure, and, you know, having been on the inside company angle, you know, it's not always what's lawful and what's not. There's a lot of other factors that weigh in here, and you know, your response needs to take in not just the law. Obviously, you want to be legally correct, but there's sometimes you may have to take slightly different actions for business purposes. And you know, I don't want to convey, and I don't think Merritt would want to convey either, that hey, as long as you're legally accurate, you're fine. Because you know, unfortunately, there's the court of public opinion doesn't necessarily follow the law.
No, I think that's absolutely correct. And a lot of times what we'll be doing as legal counsel is a client will come to us with a certain situation. We'll provide the guardrails as it relates to the legal issues, parameters, what can and cannot be done. But that's going to provide guidance as it relates to business and operational matters, which oftentimes will drive the day. So that's a very important point. Employer influence on voting. And let me just sort of go through this quickly. And I know Lewis has a case that's just coming up in Florida now, talking about a little bit. But again, as an employer, DC, you're prohibited from paying or offering to pay employees for registering to vote or voting, or threatening or intimidating employees from voting or initiatives. Maryland, employers are prohibited from influencing an individual's voting activity through intimidation or bribery, or exhibiting in the workplace any threat intended to influence the political opinions or actions during the 90 days prior to an election. In Virginia, the use of threats or bribery to influence how individuals vote is prohibited. So I think this makes sense. I think that is, so across the DMV, you know, employers hopefully have enough common sense not to be doing this. But with the scenario that Lewis will talk about right now, maybe not across the nation. Go ahead, Lewis.
Yeah, so this is actually kind of an interesting story, because I think if you read, and this gets to, you know, the court of public opinion versus the legal issue. So in the media over the last 2 days, there's been a story about a company called Daniels Manufacturing down in Florida. With the last pay stub that went out, there was a letter in there from the owner of the president and owner of the company saying, in so many words, if Biden wins, we're going to have a lot of layoffs starting at the end of 2021. Now, I think he posited, and as the owner put in the letter, he made it tied to issues, and you know, he put some political speech in there. He's coming under a lot of fire about whether or not it was appropriate to put in a letter that went out to your employees with pay stubs. I'm curious to this more on a federal election campaign law issue. That's outside of the scope of what we're talking about. I think from a speech perspective, you know, depending on what the company's policies are, he may or may not have a problem with the letter. If the company has a policy banning political speech, but then he sent a letter like that with paychecks, I think there's an argument they're violating their own policies, and that becomes problematic, because if you try to fire somebody for violating that policy, now you have a problem on your hands. So it's an interesting case to follow. Like I said, Daniels Manufacturing Corporation, it's out there in the news, you can read it, but you know, it definitely is wandering into the shade of gray for whether or not I'm trying to coerce people to vote a certain way. So we can talk about, you know, the judgment of putting something out there, even if it ties to policy. You know, there's a couple employees who claim that they're going to quit. This company's gotten a lot of bad press from a bunch of different articles. So you know, there's both legal and opinion fallouts from conducting stuff like this. I mean, I think it's very, very much on the line. If it is okay, it's very close to the line of what's okay. And you know, my advice to my clients is always, it's football season. you never want to be the wide receiver dragging your toes to stay in bounds. You always want to be the guy crossing over the middle of the field when you're doing things, because the guy with the toes on the sideline may step across the line, and that's not where you want to be as a company. I read this company. I think this guy's definitely got his toes on the line and has a risk of being called out of bounds.
And thinking about the football analogy, Lewis, when you said you want to be the guy catching the ball in the middle of the field, I played linebacker, and I was thinking the first thing that receiver is catching the ball, he's going to get smacked down. So I guess you have to think about your football analogies. But anyway,
well, it depends on whether or not you're out of bounds is what I was going for, not the hit you're going to take for staying in bounds.
You want to not go into too much into the gray. The other thing you need to think about is voting leave laws. So, are you required as an employer to give employees time to vote? So in Maryland, employers are required by law to allow employees to take 2 hours of paid leave to vote, so long as voting does not have 2 hours of continuous the employee does not have 2 hours of continuous off-duty time while the polls are open. Virginia and the DC don't have any laws requiring an employer to provide employees either paid or unpaid leave to vote. So something to keep in mind within Virginia and Maryland. Oftentimes, some employers will put it in their handbooks or otherwise voluntarily give employees the right to vote, recognizing how important it is. And Virginia does have a law, though, providing unpaid leave for employees to serve as election judges or officials on election day, although I can tell you in 23 years of doing this, I'm not sure I've ever seen that come up. So, but it is something that is on the books. We're going to go into some hypotheticals in a minute, but just for a quick summary of best practices. Implement and uniformly enforce strong no political policy that recognizes National Labor Relations Act rights. That is a mouthful, and it entails a lot, and it probably entails at least a page or two of what you should have in an employee handbook that provides restrictions on workplace activities, on political activities, and has the carve-outs for National Labor Relations Act rights. It's always good to have these policies in place. And I think another good practice is discourage managers from having political discussions. I can just speak from personal experience, both, for myself, then talking with clients. It's hard once you open a door and start talking about politics within the workplace. People are sitting around at the lunch table, start talking about certain political issues. It creates division in this day and age. It's an unfortunate truth, and it's something that I think the best practice is to discourage political discourse within a company. Lewis, anything to add on that topic?
Yeah, I think that's absolutely correct, especially in today's day and age where everything turns into a bigger issue and we see it magnified. Having a hey guys, we're not engaging in political speech in the workplace where everyone's ideas are fair is a very good plan. I think the problem is, and again, I'll go back to what I said earlier. There's a perceived belief about the president, and you're running. If people are in there supporting the president openly in your office, there are going to be some people who are going to complain that there's racial discrimination going on, and we can have value judgments of whether that's correct or not. But from a best practices standpoint, just avoiding the problem, because again, I'll go back to the starting point here. Just because you ultimately win a lawsuit or an EEO charge doesn't mean it's painless to get there. I think companies want to be smart. You don't want to discriminate against people and draw really tough lines. But you also don't want to see yourself brought into court over something that is pretty easily to avoid. And I think having very strong policies that are expressly content neutral and sticking to them in a content neutral manner is the best course of action.
Yeah. Excellent. Before we go into the hypotheticals, let's go ahead and answer a few of the questions that we have so far. Please keep the questions coming, and we'll answer them as we go along, or once we get through the hypotheticals. But let's go ahead. So here's a question. What about a private employer that does engage in both state and federal contracting that fires an employee for social media activity that occurred before the employee was hired, but was only discovered after the employee started at the job? Yeah, I think that's an interesting situation. I think we have to sort of go through, first of all, and as an employment law attorney, sort of go through different steps. Are there any federal, state laws providing protections for that employee? And most likely the answer is no in this situation. Now, I don't know what the particular circumstances were here, but I think you need to determine whether or not there's a true impact on the workplace here. Is this something that if colleagues found out about it, they might think that this person is, has discriminatory feelings, thoughts, actions in some manner. You go back to the situation of the bird watcher in New York City. That employee, it happened while she was employed by her company, but they fired her for taking actions. And once it became the name of her employer came out, they did not want to be affiliated with her actions, and the employee was fired. So I think you need to look at the circumstances here. If it's something that happened on social media before the employment commenced, again, you need to look at the circumstances, need to look to see to what extent it's going to become known throughout the company, need to determine how significant it was, and then make a value determination there. And it may be something that is not governed by legal and the law, but more what's in the best interest of the company. Lewis, do you have something to add for that circumstance?
Yeah, I mean, I think there's certain things that are cut and dry, and we'll go back to if this is an at-will employment context, right? The company has a lot of flexibility to make a decision. But if you find out after hiring somebody that he has, he's been out on Twitter or on Facebook making racial comments or demeaning comments towards women, I think that's a pretty clear-cut case that you can let him go on the spot. I mean, there's things that go towards character. You have the capability to do it. Again, you see some of these athletes who I've seen drug through the mud because they made stupid comments when they were 15 years old. Is one thing, but if you find out 3 months ago someone posted a racist screed on social media, I think you can react accordingly. Again, it comes down to whether or not you have you have an at-will relationship, and also whether you have a probationary period for your new employees. Those are things that I think Merit as a long-term employment lawyer would probably counsel you to have both of those to give you a little more flexibility just for those circumstances. You find something out after somebody starts, you want to give yourself maximum flexibility at that point.
Yeah, and even without the probationary period, which different employers have different views on, as at-will employment, again, have to fall back. You don't have rights in certain political speech unless you're tying in terms and conditions of employment. So with at-will employment, you can let the person go anytime, any reason, as long as you're not implementing state or federal laws. Next question was, can you provide a sample of a good prohibited political activity policy? If I was being cheeky, I might suggest that you talk to your employment law counsel, and they might be able to provide one for you, or look at your employee handbook and make sure what you have is sufficient or help you review it. But if you follow up with an email, perhaps we could help out in that circumstance. I don't think we have one prepared as part of this webinar just to distribute at this time. Next question, should we discourage employee discussions regarding social injustice issues? And that's a tough one. In the past several months, I've seen a number of companies, CEOs, leadership send out emails from the CEO, president of a company, talking about social injustice issues, talking about the company's view on Black Lives Matter, companies' view on immigration issues, the company's view on, women in the workplace, whatever it may be, where you need to be careful, and it's sort of how it impacts the cohesion of the employment atmosphere. You don't want to create discord among the employees. So having the company leadership provide aspirational leadership of, we support certain rights and values. And those are the same sorts of rights and values that are discussed within your employee handbook as a non-discriminatory EEO company. I think that is worthwhile. Sitting around the lunch table and having team meetings discussing other perhaps potentially controversial issues, I think you just need to be very careful about how you do it. So with that, let's jump into some of the hypotheticals that hopefully provide some more guidance on how we would do some of these, and it's just sort of going through some of the issues that we've talked about and putting it into some real life scenarios. So question, company doesn't require a uniform. Can the employer prohibit employees from wearing Trump or political shirts? And I think everyone should know clearly the answer is yes. You can create and enforce policies requiring employees to adhere to a reasonable dress code. As noted on the bottom, if the shirt says, Biden for safer working conditions, I think you need to be careful because that may be protected by the National Labor Relations Act. If it's just Biden is better, then that would be prohibited. So be careful in that regard. Lewis, anything to add to dress code?
No, I think that I think you kind of hit it. Again, this is the we'll keep beating the drum of content neutral is your friend here, and as long as you have a policy that's enforced across the board of the political spectrum, you'll be okay.
Mm-hmm. Next question is on voting leave. I'm an employer in Virginia. Do I have to allow my employees time to vote? As we answered, no. Virginia does not require employers to allow employees leave to vote, whether paid or unpaid. Again, I know a number of employers do have that voluntarily within their employee handbook. If it is in the employee handbook, you should honor it, but it is not something that is legally required, except as we said, for those election officials that there could be some rights for. Employer influence in voting. My employer supports Joe Biden. Can they offer me a $100 bonus to vote for Biden? Can they threaten to fire me if I do not? No, you cannot do that. In most states, including Virginia and Maryland, the use of threats or bribery to influence how individuals vote is prohibited. And that does get down to the issue that Lewis was talking about in Florida, making a bold statement, if you vote a certain way, our industry may change and you're going to lose your job. How is that going to be interpreted? I think as employment law counsel, we often urge constraint and moderation in how you take action as an employer. It's better to be safe oftentimes and walk, as Lewis said, stay in the middle of the field than risk potential lawsuit or creating division within your company. Next question, social media. An employee is advocating for a political candidate and promotes extremist ideologies on his personal Facebook page. Can he be fired? The answer is generally yes, unless the employee's employment contract states otherwise. So, unless they have a contract or a collective bargaining agreement, they're going to be at will. So as an at-will employee, political speech, and as we talked about with the woman in Central Park with the bird watcher, or flipping the bird off to President Trump as he drove by, you can terminate people for their activities as long as they're not protected, since they are at-will employees. We do have DC and some Maryland counties, what do we say, Prince George's and Howard County, do prohibit discrimination based on political affiliation. So can you terminate someone based on, flipping off President Trump? Probably yes. Could you, in DC, terminate that same person because they said, because they're a Republican or they're a Democrat? The answer would be no in that circumstance. So it is, what is that distinction right there? And obviously the third part we have here is consult with counsel. This is an issue where you need to be careful. And I generally like employers, even if it's just a 10 or 15-minute call, we're thinking of taking this action, any landmines that you see here, and want to be careful to avoid landmines, because that 10, 15-minute call to an employer, an employment law attorney, can often save, a lot of trouble on the back end.
Yes, on that account, I always try to point people, Benjamin Franklin was a very smart man, and one of his best quotes is, an ounce of prevention beats a pound of cure. So picking up the phone and calling us and having a 15-minute conversation today or tomorrow is going to be a heck of a lot easier and, more importantly, cheaper than having to defend an EEO charge 6 months from now. So definitely, keep that in mind. People, and I've been on the side of getting beat up about legal bills when I was an in-house counsel. But sometimes, think of it like an oil change. Changing your oil regularly costs you money, but it's a lot cheaper than replacing an engine. So, I definitely, in this area, you should always make a phone call and kick around the ideas to figure out what's legal, and then even if it's legal, what really makes sense.
Exactly. Oh, excuse me. All right. Next we have Joey supports Joe Biden, even though a number of coworkers have asked him not to. He keeps talking about politics in the workplace. Can he be fired? Yes, as hope everyone knows at this point, whether he supports Biden, Trump, or an independent, you can enforce policies against harassing other employees, and if the political disruptions disrupt the workplace. Ensure that the policies are enforced consistently and not in response to an employee's personal political views. And you also need to be careful, if Joey is not just talking about his political candidate, but he's talking about the political party. I think everyone should vote for, Republican, Democrat, because of their views and how it's going to impact us in the workplace. And it can get us better wages. It can protect our jobs because there'll be less immigrants, because whatever the argument is, if it goes back to that concerted activity, the National Labor Relations Act, terms and conditions, you need to be careful in what the prohibitions are. So just be careful in that regard. Have the policies in place in your handbook and make sure you're applying them uniformly and consistently. Next, friend makes an announcement overheard by a number of coworkers that anyone who votes for Biden or Trump is foolish, is an idiot. Can he be fired? The answer is yes. Employees can, again, enforce policies against harassing employees, make sure they're enforced consistently. That is not protected speech. So as we go through this, you look to see, is there any law providing protection to Fred in the circumstance? And the answer is no. If he's just saying you vote for Biden, you're an idiot, that's not protected speech. Next, Scott skipped work to go to a Donald Trump rally. Can he be fired? He skipped work. That's what's relevant there. So you're permitted to enforce attendance policies. So in that regard, if he misses work, it's an unexcused absence, can be terminated. Now, I think what you need to do in that circumstance, though, is make sure that, again, you are uniformly and consistently enforcing these policies. If Scott skipped work to go to the rally for Donald Trump, but Susan skipped work to go fishing and she didn't have any ramifications, well, that's not being applied consistently. So you need to be careful in that regard. Conclusions, and then we can answer some more questions and try to finish up within an hour. So we have about 5 minutes. Politics in the workplace is not an easy topic. And I think it's getting harder and harder as the country becomes more polarized. Employers should have policies that recognize National Labor Relations Act rights while setting guidelines for political speech and using employer tools. Again, that's a mouthful, but I think, like you have dealing with other employment issues, you need to have policies and procedures in place within your employee handbook that set forth the guidelines. And I think you also should have a standard policy for working. Political discussions should be discouraged. I think it's just something that we need to be careful. Louis, do you have sort of a few concluding thoughts, and then we'll see if there are any additional questions?
No, like I said, I'll keep beating the same drum. The best way to keep yourself out of trouble is with a content neutral policy. But on top of that, I will put the second layer on there that just because you can doesn't mean you should. I have these conversations with clients all the time. Yes, you have the right to take this action, but let's talk about the second and third order effects of that action. So yes, you want to be content neutral, but you also want to do things that make sense. You have a workforce that you want, for the most part, to be happy. And this is a field of landmines, and it's something that has to be thought out carefully before you make any kind of quick reactions or judgments. Would be my my number one advice: is no knee-jerk reactions in this area.
Very good. We have a question. Does it make a difference if political speech in question is largely satirical or sarcastic in nature? I don't think that really changes the analysis. Again, the analysis is going to be, is it protected speech? And generally speaking, there is no protection for political activity, unless you have National Labor Relations Act or unless you have state or local laws come into play. So if there is, the satirical or sarcastic nature, that is not going to be something that is going to create any additional rights for the employee engaging that.
And on those lines, not everyone gets it, right? So you may think you're being funny or sarcastic. Not everyone will get it. Not a legal story, but a relevant to this topic story. When I was deployed to Afghanistan, we would do movie nights, and one night we watched Blazing Saddles. If you're familiar with Blazing Saddles, you can probably see where this is going. That movie makes fun of racism. But if you don't get it, it's built on sarcasm. It looks like on a surface that it's a racist movie. And there was a complaint from someone that the movie was a poor choice and was racist. And that's a perfect example of, somebody might see something and understand the sarcasm and humor intended. Not everyone does. So trying to say, oh, well, he didn't mean it, it was a joke, is not really a very good defense.
Exactly. Well, great. I don't see any other questions. So thank you, everyone. I hope this was a beneficial overview of, political activity, rights for employees, responsibilities, and best practices for employers. If you have any questions, please consider contacting myself or Louis Rhodes. Our emails are here, as is our phone number. Please consider visiting our website. There's a lot of additional information there on this topic and others. And obviously, as a law firm, we are here to help you however you need it. So thank you very much. Take care and goodbye.